I guess I say good afternoon because it shouldn't be more than nowhere where nobody's at, right? What's up? I know. Hey, what's up, Rachel? Oh, Jason, he back. Welcome back. Welcome back. Welcome back. Hey, pretty. What's going on? Hey, Baka. Hey, Barbara. Barbara. Hey. Oh, okay. So how many of y'all gonna raise your hand and say we was out here on these YouTube streets today trying to figure out what to do with ourselves? I was like, I woke up this morning and I'm like, okay, this is the first time that we ever been really like caught up with some stuff, right? Hey Tilly, like I'm like, okay, we caught up with everything. I'm like, I cannot premiere day 4 of the beheading trial because we had all of that cell phone data that was so boring. Hey therapist, I was like, that was so boring. I'm like, okay, so we can't watch that. That's not gonna work. I know we doing our case prep later today, but what are we supposed to do in the meantime, in between time? So, and I was out here on these YouTube streets and I'm like, okay. Oh, look at there. Oh, Jason, thank you, thank you, thank you. 3 months. Wow, it's been 3 months already. She said she been watching her Sims videos and all her and wig tutorials. Okay, we're gonna have to send you into the jail so you can make sure all our people with their wigs be together. Yeah, so I was like, okay, well, I know that we have watched parts of the head and body trial, right? We end up dumping that trial, but we did watch the verdict. And now he's coming up for sentencing. So I figure we can all get together and watch the sentencing. But yeah, we dumped this trial because he kept going and he went in out of we watched video of really Adore. If y'all thought that the testimony from yesterday was bad, this watching this guy walk in and out of this door for 2 days straight with testimony was so. Hey Ruth Ann, how are you? It's been a while. Yeah, so let me get this up for us and see. Um because they had a problem with him. I know I had seen where they was having a problem, with the scheduling, but look like they may have got it together. Because I know the judge was like, well, wait a minute, we gotta let some people get here. So let me get that up here for us. So I guess after we get finished with the sentencing, I will um I will I will open up the room and we can go right into our next part of our day. I done had some issues and I'm gonna set that up on the back end because I don't know, for some reason is the server is allowing me to stream in 2 different formats, but when I send it out, it's sending out 2 alerts now. So I had to delete all of my things. So I'm so glad that everybody's able to get it and we're able to come in normally. Um Let's see here. So we will see what's going on with our guy here and see what his life be like. I know that the judge. Let me go in here real quick. Let me turn this on. Okay. If y'all ready, I'm ready. We ready. We can see some ones and some SweetP games, and we can go into this courtroom and see what we got going on in regards to our guy, Mr. Pahl. And not spelled Paul. It is spelled Pahl. Pahl. Interesting. I graduated it sometimes. They expensive. All these coffee places are expensive. Hey, Marilda. I thought I seen you sneak on in here. Let's go in here and see what is going on here. What he about to get? What he got to say about himself?
All right, I'll call the matter, State of Wisconsin versus Matthew Pahl. This is 23 CF 1438. Let's have appearances, please.
Christy Gordon for the state, along with Sue Opper.
Attorney Gallivis here with Attorney Wilk, sitting here to our right is our client, Mr. Pahl, in custody. Good afternoon, Judge.
All right, good afternoon, everybody. The matter is here for sentencing today. Has the state complied with victim notification requirements, ma'am?
Yes, Judge, the victims are just coming into court now. All of the victims are going to be present in person, not by Zoom.
Okay, and to your knowledge, do any of them wish to make a statement today?
I have a written statement from Miss Layla, who would like this. I will be reading her statement for her, but none of the other family members wish to make a statement to the court.
Okay. From the state's perspective, is there anything we need to take up before we start with sentencing?
I do have a restitution figure.
How about the PSI?
All right, and have you shared that with the defense?
Okay. Yes, we have shared that with the defense.
All right, and what is the amount?
$8,309, and that is for the cost of funeral expenses.
Okay. And is there a dispute as to that amount?
I've never seen this.
Okay, that's fine. We can talk to your client about it later on, and I can set a hearing if we need to do that, okay? Anything else other than that, Ms. Gordon?
No, Judge, I believe all the victims are in the courtroom now.
Okay. Mr. Galaviz, anything before we start, sir?
Apparently, Mr. Pahl is discussed something about PSI that he wants to put on the tape, on the record. I think,
What's going on, Mr. Galaviz? You're the lawyer. You tell me. You can talk to your client, but let me know.
Let's finish this.
Finish it with what?
Mr. Wolf, Mr. Galavis?
Judge, I don't think Mr. Paul knows what he wants to do with the PSIs, so I think we've advised him not to request a PSI.
All right, my intent is to move forward today.
Good.
All right, anything
sir.
else, Mr. Galavis?
No, sir.
All right, there's a couple of things that I have to take up first and foremost, because, Mr. Paul, you've been convicted of a felony offense. You may not vote in any election until your civil rights are restored, and because you've been convicted of a felony, it is unlawful for you to possess a firearm. If you ever possess a firearm, you could be found guilty of a serious offense, resulting in up to a 10-year term of imprisonment and a $25,000 fine or both. And because you've been convicted of a violent felony, it is unlawful for you to possess body armor. Those are admonitions that are required by law that I have to advise. All right, state's ready to move forward?
Yes, Judge.
All right, let's go.
Thank you, Judge. The state is making a recommendation of life without the possibility of parole. As the court knows, on count 1, having been found guilty, the court can make 3 determinations. First, determine if the defendant is eligible for parole after 20 years. 2, by some other date, or 3rd, not eligible at all. And the state is making the 3rd request that the court find the defendant not eligible for parole.
Extended supervision.
Sorry, correct.
Correct.
Yes, thank you. On count 2, a Class F felony, the state is asking for the maximum sentence consecutive to the life without possibility of extended supervision. We have consulted with the victims. The victims are in agreement with this. Judge, you've heard all of the evidence, and I think the only thing the court hasn't heard is about Mr. Paul's prior record. He has a 2005 conviction for resisting or obstructing, and he has a 1989 conviction for 3 counts of delivery of cocaine. He was sentenced to 15 years of prison in 1989, and he was in and out of prison for a number of probation or parole violations during that time. He had also been charged with physical abuse of a child. Him and Ms. Pavlons were both charged with physical abuse of a child related to Layla. That was ultimately dismissed as part of an agreement with the state. He also had a 2012 charge for possession of controlled substance along with that incident. But most importantly, in 1993, he was investigated for first-degree intentional homicide. He was ultimately never charged. That was in Milwaukee. And as part of this investigation, the state reviewed those police reports to determine know a little bit more about Mr. Paul. But also, as the court may remember, the state had sought to introduce some evidence from Tanya Bean, which was Mr. Paul's ex-girlfriend, as part of other acts evidence. And ultimately, the court found that that was too remote in time. But I think that this investigation that Milwaukee completed with Mr. Paul as the prime suspect just shows the violence that the defendant has had for his entire life. And the gist of that case was that Mr. Paul and Miss Bean were dating. Miss Bean had a bit of a controlled substance problem, and the person that was ultimately killed was Miss Bean's drug dealer. And there was a dispute about whether Miss Bean was cheating on Mr. Paul with the drug dealer. And there was not enough evidence to charge Mr. Paul with first-degree intentional homicide, but he was ultimately referred over to the Milwaukee DA's office, and he was the only suspect in that case. Here, Judge, we have a long history of domestic violence. And as the court knows, even though it was not admitted at trial, there's a history of domestic violence going back even to Tanya Bean, the girlfriend Mr. Paul had prior to Ms. Pavlons. And the history continued for Ms. Pavlons' entire dating history with Mr. Paul. And as the court knows, more than even what the jury knows, because there was a lot of other acts evidence that the state presented to the court that was ultimately maybe not admitted to the jury for different reasons. But I think it shows that Mr. Paul is a violent and abusive man. He is the epitome of domestic violence. And as I made my arguments and closing arguments, it's very clear that on August 23rd of 2022, Mr. Paul was met with a decision. Either let Ms. Pavlons leave him or take action into his own hands. And he took action into his own hands that day. He was not going to allow Ms. Pavlons to walk away from this relationship, even though he maybe didn't want to be with her, even though he wanted to go to the Philippines. I think that he is absolutely a danger to the public. He's absolutely a danger to any woman he would ever become in a relationship with in the future, which is why I'm asking that the court not make him eligible for extended supervision, because I do think that there's just absolutely no question in my mind, based on his conduct in this case, that he cannot be in the community in the future. I'm asking that the court sentence the defendant to a consecutive sentence on the hiding a corpse, because I think that charge makes this case all the more aggravated. Ms. Pavlons decomposed in the woods for 17 days. There was evidence of significant insect activity over those 17 days, and ultimately her demise became very difficult for the state to prove the cause of death, the manner of death, because of the actions of hiding her body in that wooded area. And clearly the jury found very quickly that not only did Mr. Pahl kill Ms. Pavlons, but he also hid her body. He put it in a place where no one was going to find it. And that place was really almost in plain sight, right? There's a lot of people that come and go from that area, but for 17 days, no one found Ms. Pavlons. I believe that that charge is very aggravated. That aggravates this whole situation and certainly changed the amount of evidence the state was able to find forensically on Ms. Pavlons' body at the time of her autopsy. That contributed, obviously, to the state needing to have a forensic entomologist, a forensic anthropologist, just to determine what happened to Ms. Pavlons. I do have a statement from Ms. Layla Pavlons that I would like to read. She says, "She was my mother. She was a daughter. A 22-year-old woman should not be going through losing a mother at 44, and my grandparents should not be going through losing their second child. I could see you hurt her. I do not know why she would tolerate your abuse, and I might never know why. What kind of sick monster would do that to an innocent woman that spent her life with you, cared for you, and was there for you when she could be? You have no soul. You killed the one person that made me happy and was there for me at times I needed her. The one mother, the one daughter of my grandparents is gone. I feel like it was on me to push her harder to leave you. Our family should not be going through this pain that you have caused, and it can't be undone. A man that hits and abuses an innocent woman is not a man, but a weak, sick-minded individual. A woman that had a daughter died because of you. She was in pain. I could see it by the way she talked about you. I could see it when I visited. You took an innocent woman's life and hurt so many people. I hope you rot in jail." I think the pain that Layla Pavlons and the Pavlons family feels of the actions of the defendant is so real. And Layla's right. A woman was taken much too early. She lost her life, her daughter lost her mother, and her parents lost their daughter. It's an unimaginable situation for Layla to be sitting here in court today on the sentencing of her father for killing her mother. Two people that should love each other, should love and protect her, have now placed her in this very terrible position. Mr. Pahl doesn't even really accept his sense of being a father to Layla. They'd had no contact in years, and you saw those texts to those women. He called Layla his niece rather than saying that that's his daughter. Mr. Pahl did terrible things to his family, but most of all, he did terrible things to Stephanie. And I believe that he should sit in prison for the rest of his life and have to think about what he did and what he's done to Ms. Pavlons' family. Because that will never, no amount of jail time, no amount of prison time will bring her back. But there will be some justice for Stephanie. So, Judge, I am asking that you run those sentences consecutive to one another. As the evidence showed, this was a circumstantial case, but one that clearly the jury felt was overwhelming, that within an hour they were able to come to the decision that Mr. Pahl was absolutely the person that killed Stephanie Pavlons, that he had made her life miserable for years, and that he then hid her body. Mr. and Mrs. Pavlons are asking for $8,309 in restitution for funeral costs. So we are asking that that come out of Mr. Pahl's prison wages in the future. And I just want to check with the family and make sure that they don't want to make any statements.
All right, go ahead.
In speaking with Mr. and Mrs. Pavlons through the course of this investigation, it took a long time to bring Mr. Pahl to charges and ultimately for him to be sentenced here today. I know that they feel a great sense of relief that this is over, but also that they have lost something so precious to them, and they were hearing for the first time in court some of these horrible acts of domestic violence that were occurring to Stephanie, and that loss will never be undone. Thank you, Judge.
All right, thank you. I calculated 792 days credit. He was taken into custody September 19th of 2023.
September 18th of
18th.
2023.
Anyway, you can calculate that as well. Mr. Galloway, Mr. Wolf?
Judge, I'll accept the court's number of 792 as
Right.
credit. As far as sentencing, given the state's theory in this case in the rebuttal, this was not a first-degree intentional homicide. If you follow their theory, this was at best a first-degree reckless homicide or a felony murder, not first-degree intentional. So I think that's an issue for appellate purposes. Also, given their theory, I made a mistake by never testing that purse. Never in my wildest dream did I think the state was going to argue that Miss Pavlons was strangled with the chain of the purse. That didn't even make sense to me when she was making that argument, and then he threw the purse in the car, and that's why the dog hit on the car. I'm not sure why the jury accepted that at all. It didn't make sense to me at all. So I made a mistake in this case by never testing that purse. Had I known that that was going to be their theory, I don't think they knew at all that was going to be their theory until sometime during their case in chief or while we were presenting their defense. But that's going to be an appellate issue. As far as the court considering the Bean incident, I don't think you can, Judge. I mean, if the Milwaukee Police Department and the DA's office believe that they didn't have probable cause to even charge Mr. Pahl, which is a low burden, sentencing courts have indicated that the court shouldn't consider that. It's not even probable cause. But ultimately, you are the gatekeeper in this case. As far as Mr. Pahl being a father, or how he was as a father, I guess it goes to his character, but there's a lot of unfit fathers in this world. As the court has run into many of them who sit at this table as defendants. Mr. Pahl, I'm not sure what to say. He's still claiming his innocence. Given the position of the state in its argument at closing and the issues that it's raised on appeal, as far as in my negligence of not testing that purse, I'm hoping that the court gives the defendant a mandatory minimum. Other than that, I have nothing else to say. Mr. Pahl may wish to give a statement. I'll leave it up to him.
All right, Mr. Pahl, do you wish to make a statement, sir?
Of course I'm going to make a statement.
Okay.
Yeah.
Go ahead, sir.
First, I just want to correct some of the puke coming out of Gordon's mouth. Whatever this 2012, I mean, this is how this stuff starts, this fabrication, these wild stories, wild imagination. I was never charged with any possession in 2012. I believe that was Stephanie. In this 93 police report, I read that there were many suspects in there, and I had nothing to do with anything that happened down there. I didn't commit any murder in Milwaukee. And this stuff about being a parent, I was only a parent till Layla was about 9 years old. I was never given a chance to be a parent after that age because of all the goofy stuff that was happening here in court with the chips and custody and all that. And one of the state doctors that was prescribing Layla medication ended up losing his license because he was over-prescribing to minors. I think that's one of the reasons why Layla was on so much medication when she was younger. He was never charged, but he lost his license. His name was Dr. Ronald Rubin. I mean, you can look into that, and that was one of the people that actually made decisions about my character. And, you know, I mean, we could go into a rabbit hole about his character. And I just want to make a statement about this case. I look at the justice system here in the United States. It's about winning. It's not about the truth. The U.S. has 4% of the world's population. 20% of the people behind bars on this planet are here in the United States or on probation. Why? Maybe sham trials. And I think this was definitely a sham trial called Making a Murderer here in Waukesha. It was definitely a pseudo-sham trial where psychopaths in suits fabricated extreme circumstantial events and turned them into their wild imagination. No wonder why they get away with manufacturing charges. The public and jury believe these lies and story. Missing in this whirlwind of hysterical hyperbole was I was seen with 3 little green men hovering above the woods in a dish-shaped object going down in a beam of light. The good old boys, for some reason, didn't focus on the truth that the scalpel found in the woods was most likely used by Stephanie's own hand, and then possibly a seizure, because I was never in the woods. The dog and truck was prejudiced against me. It was just blatantly silly and probably thought out in advance. The detectives tried to alter the suicide note right here in court, right before the court's eyes. Crazy enough, Stephanie's heroin and drug charges back in 2013, the same DA's office wanted Stephanie in prison for a long time or institutionalized and considered her dangerous. Maybe if these so-called professionals did their job, we wouldn't be here. How deep does this rabbit hole go? Well, maybe one day on review for this huge blunder, these people here better have the right answers, because I am the only victim here. I'm the one being murdered by the new Gestapo. All the testimony showed no smoking gun, except the police think or thought I did something. This is prosecution, not justice, by a tyrannical fascist dictator government here in Waukesha. Coming to my house with a tank and then wondering why I couldn't remember accurate details about the purse and phone. It's amazing I can remember anything. Yes, I did exhibit some odd, maybe strange paranoid behavior by not calling the police. But if you look at my past cases fabricated against me, where I told the truth and I was still charged. Also, Stephanie was involved in some of that fabrication too. This took years off my life fighting. Opera and the Klan know what I mean. The mark on Layla's butt, alleged that was never there. Punching a man, breaking a window. I was never there at the time. Just like this case, I was never in the woods. This is just a pattern of abuse of power in the DA's office. Statements I was accused of saying, I am in trouble, I will be ready for police, and many more, came from Opera's delusional mind. Detectives making Layla believe she will get money if I am convicted was a sick tactic. She will hopefully one day see the truth. And before this incident happened, I can honestly say she was never there for her mother. I mean, if you see the text messages, she sent a lot of nasty messages to her mother. And I'm ashamed that she's my daughter and part of the Pavlons clan. I'd like to say more on that, but not now. Stephanie and I had some fights, as in any relationship, but never to the level of murder. Texts about alleged violence were over-exaggerated. She used to tell me all the time, and my family, that her father used to beat her. Is it true? I don't know. I do know that drug addicts will say anything to get sympathy and attention. When I first met Stephanie, I helped her get off drugs, drinking. I got her a job, a car, I got her license back, and out of a gang in Milwaukee. Her mother knows how she broke her wrist. Off drugs and alcohol, Stephanie was a kind, giving, and loving woman. We were separated since 2012, but we still loved each other and would have taken a bullet for each other. She would never have wanted me in this situation. I love and miss the drug-free, hype-free side of Stephanie. However, I became tired of her problems and addiction. Her constantly taking off, hiding with her medications, all the erratic behavior she exhibited. I was supposed to bring her home on the 23rd, but the truth is she did not want to go because she hated her parents. I wish I could have skipped my appointment at OPA and figured out some way how I could have helped her more. And I believe the parents knew that she was going to die. That's one of the first things that the mother said, that she was feeling that her daughter was going to die, either suicide or an OD. I am one of the innocent people in jail from a sham trial. You know, maybe I'll be on wrongful conviction someday, I don't know. But I would, again, like I said in my statement to the detectives, I would rather stand with God and be judged by the people than stand with the people and be judged by God. That's it.
All right, thank you very much. Mr. Galaviz, anything else?
No, sir, thank you.
Okay. All right, so when I sentence an individual, and whether it be for, you know, a drunken driving, a lower level offense, a retail theft, or as in this case, first-degree intentional homicide in the charge in count 2, hiding a corpse, there's certain criteria that every court is supposed to look at, and which I do look at and consider. I abbreviate them by indicating that I look at the impact on the community, the criminal, the individual, Mr. Pahl himself, and the nature of the offense. And I'm going to talk about those things as we move forward, and I'm going to talk about some of the other aspects of this trial, the individual aspects of this trial that came into play. And I'm also going to take into consideration the statements made by the victims, Layla Pavlons, the statements made by the state, the statements made by defense counsel, and Mr. Pahl, of course, himself. Those are all things that I consider. So let's talk about first what the community impact is. And first, we have to frame what these offenses are. The legislature has indicated that in count 1, this court is required to impose a term of life imprisonment. And then pursuant to 973.014 of the Wisconsin statutes, I can make a determination about the availability of extended supervision, or the eligibility for extended supervision. And that's something that the court takes into consideration today as well. I also look at the nature of the second count. It has as a potential penalty 12.5 years of imprisonment, meaning 7.5 years initial confinement, 5 years of extended supervision. That is the potential. And the court can make a determination as to whether the sentences can be consecutive or concurrent as well. So there are things that I need to consider here. And there are certain factors that I have to look at in making those considerations in terms of how I'm going to structure a sentence or sentences in this case. Let's go back to the community issues. First of all, when I talk about community, what I mean to say is both the community as a whole, Waukesha County, the city of Waukesha, the people in and around this area. I also look at the Pavlons family members. I know that the parents have been here, and I know that Layla Pavlons has been here, and their testimony was part and parcel, or not necessarily their testimony, but their presence in the case was part and parcel of what occurred here. And I look at the statement made by Layla Pavlons, because it pertains to both her mother, the victim, and her father, the convicted defendant in this case. And so what she has had to say to me and her wishes are important to the court. Let's take a look first at the community as a whole. And I think when I do that, the way I have to frame that is looking at what was said and what was proved and what was determined during the course of the trial, and how that impacts the community first as a whole. Now, granted, we understand that the death of Stephanie Pavlons has a profound effect on her parents and her daughter as well. And whatever the relationship they had, and whether it was antagonistic at times, whether it was loving at times, or whether it was a combination of those things, the parents lost a daughter, the daughter lost a mother, and it apparently has a profound impact on them. But again, let's take a look at the community. What I see in this case is domestic violence. And what I see in this case is an individual, Mr. Pahl, who did what he could to exhibit or to exert power and control over Stephanie Pavlons over the years, over the decades perhaps. And I'll talk a little bit more about that. And so I'm very cognizant of the fact that when I sentence Mr. Pahl as an individual, that I'm sentencing Mr. Pahl as an example of a domestic abuser, right? And we'll talk a little bit more about that as we move forward. And so when I sentence him, I'm making a statement to Layla Pavlons, to Stephanie's parents, and I'm making a statement to the community as a whole as well. Let's look at Mr. Pahl and his criminal history, and let's look at Mr. Pahl as an individual. Now, although I didn't hear much about his pro-social activities that he may have been engaging in, whether he was working, whether he was contributing to the community in some way, there may have been that. But what I heard about mostly is today a history of criminal behavior. And what's important to me, and I want to be really very, very clear here, reference was made to this 1993 investigation into a first-degree intentional homicide. I am not considering that as a factor in terms of sentencing today. I can, and I would if I knew more about it, and if I had more information. And again, I know that in the motions prior to the trial, that issue was raised, but I never felt that I had a familiarity with it to make any consideration, and I do not consider it at the time of sentencing today. But what I do consider is prior correctional experience, right? I know that there was a conviction in 1989, there was a apparent misdemeanor conviction in 05, and there was a prison term and then in and out for violations. That's what I was advised by the state today. So that says something to me. There's a history of criminal convictions. There's a history of behavior while under the supervision of the Department of Corrections that was not optimal, to say the least, right? Let's look at Mr. Pahl's support. I don't have any support. I don't have any family members. I know someone was here for him during the course of the trial, but I don't know of anybody who's going to say, you know, if Mr. Pahl comes back to the community, we're going to make sure that, you know, we're going to support him. We're going to make sure that he stays out of trouble. I don't have that. And so I have a lack of information about his ability to reintegrate into the community and be a productive member of the community. Now, let's take a look at the crime. And when I say let's take a look at the crime, or crimes I should say, there's a couple different levels that I look at. First of all, I look at the law, the black and white about the crimes. We have first-degree intentional homicide, which requires, which mandates a life sentence. The law says, the legislature said, this is what you have to order. The legislature also said that pursuant to 973.014, the court may or could exercise its discretion and provide for an opportunity or eligibility for extended supervision after a minimum of 20 years in terms of initial confinement. So there's that. That's what the legislature told me. They said, this is a serious offense. It merits, Judge, you don't have a choice. You have to impose a life sentence, but you can find somebody eligible for extended supervision at some time after 20 years. That's a possibility. We look at count 2, and again, I indicated 12 and a half years imprisonment, 7.5 initial confinement, 5 years extended supervision, and I have the option of ordering that be consecutive or concurrent as well. So that's the framework. That's what the legislature said. These are serious criminal charges and offenses. And then I also look at the crime in and of itself. So what happened here, right? Mr. Pahl and Ms. Pavlons had a long, decades-long, tumultuous relationship. It was a relationship that certainly had some bright spots. Mr. Pahl said that himself today. But this relationship that was perceived by this court in the course of trial and by the jurors, perhaps, as one where Mr. Pahl exerted financial control over Ms. Pavlons, where Mr. Pahl exerted emotional control over Ms. Pavlons, where Mr. Pahl exerted control over Ms. Pavlons' medication, where he exerted abusive and violent physical control over Ms. Pavlons. And again, we have those diaries from 2020 and 2021 that made reference to those beatings. I can't characterize them as anything else other than beatings that he administered to her to, perhaps in his mind, correct her behavior, to control her, to do, in his mind, what was the right thing for her or him. So he exerted that control. And again, I think as Ms. Gordon said, and I strenuously object to the term that it was puke from Ms. Gordon's mouth, because it is classic examples of domestic violence. Power and control. Financial control, emotional control, physical control. That's what we're talking about, right? So that's the kind of life that Stephanie Pavlons lived. All these behaviors are consistent with classic examples of power and control and domestic violence visited by the defendant on Stephanie Pavlons. And sadly and tragically, when she decided to terminate the relationship, and I make reference to the note in the trunk, and again, the suggestion that evidence was created or manufactured or altered is, in this court's estimation, pure nonsense, except as it pertains to Mr. Pahl, who attempted to refashion, who attempted to create, who attempted to alter evidence to throw suspicion away from him. That's who is responsible for manufacturing or creating or altering evidence. So that note was important because it is a contemporaneous note, as we can understand it from the facts in this case, where Ms. Pavlon said, I've had enough of this. I'm finished with this. I'm done with this. I don't want to do this anymore. I'm sick of it all. Here's how you get access to the money. Here's the PIN number. Here's how you get access to such and such account. This was her attempt to leave. This was her attempt to exert her independence from Mr. Pahl. And this resulted in his exerting the ultimate control. You don't leave, you don't have the choice, Ms. Pavlons, and whether or not he was going to go to the Philippines to live with other women, he couldn't, in his arrogance and his ego, have someone else tell him it's over. And so he killed her. And the cause and the manner, perhaps unknown exactly, but he killed her. That's what the jury said. So I look at these things and I think to myself, what am I going to do with somebody who does these things, right? Let's talk a little bit more about the offense. Let's talk about count number 2, right? Now, it would be absurd to think that, Mr. Pahl was going to turn himself into authorities and say, I killed her, come and collect her body so it doesn't rot in the woods. But that's what he didn't do, right? Of course he did. He killed her and he left her to rot in the woods as if she was roadkill. And the condition of her body, the debasement of her by leaving her to rot in the woods added insult upon injury, literally and figuratively. So what's happened now? And I want to say something. I want to read, we talk about circumstantial evidence, right? And this case was a circumstantial case. Let me read this instruction again. It says, and it defines circumstantial evidence according to Wisconsin law. It says, it is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. So what happened in this case? The state presented its case. Ms. Opper, in her opening, said to the jury, have patience. It's going to take a long time. We're going to put the pieces together. You're going to see what happened here. You're going to be able to find Mr. Pahl guilty of these 2 counts, first-degree intentional homicide and hiding a corpse. And lo and behold, that's what happened. The jury has spoken. The jury has spoken clearly and, quite honestly, rather succinctly. In a case based on circumstantial evidence. And I'm going to tell you, Mr. Pahl, that this jury deliberated for less than 1 hour. They walked out of here at 3:20. We keep track of this. And at 4:20, I was told that they had a verdict. The jury deliberated for less than 1 hour and found you guilty on both counts. And when I say succinctly, what I'm saying that they did it in very quick fashion, without hesitation. And I will tell you this, in my 40-plus years of legal experience, to my recollection, this is the fastest verdict on a first-degree intentional homicide that I can recall. So, it wasn't like, hey, maybe Pahl did it, maybe Mr. Pahl didn't do it. What do you think, or what do you think? I don't know, they came back in less than an hour and they spoke to me, to the state, to you, to the community. Mr. Pahl is guilty beyond a reasonable doubt to these offenses. Now, again, your position is that you are not guilty. That is your right, and that is, guarded by the Constitution of the United States, and that's fine. I have no qualms with your claim of innocence, not at all. But what I do have concern about is you're characterizing this as a sham trial, manufactured charges. You make light of the system. You believe that the state created evidence, that you're the only victim here, that this is a fascist dictator government, and Opper and her clan know what you mean, and Opper's got a delusional mind. Mr. Pahl, I'm not a psychiatrist or a psychologist, but the things that I see about you, you're the center of the universe. The universe revolves around you. Everybody's wrong. You're the only one that's right. You shake your head in the negative as I say this to you, and that's okay. That's your right to do that. But, sir, what you have exhibited to me demonstrates to me what I consider, and again, I'm not a shrink. This is what I consider to be narcissistic behavior. How could anyone not believe that I'm innocent? How is it that everybody gets it wrong, and I'm the only one that gets it right? And what's important about that is that those characteristics, your personality tells me what I have to do. It tells me loud and clear. The jury told me loud and clear in less than an hour, and your statements and your behavior and your attitude tells me loud and clear, as we sit here today, what is the appropriate thing for me to do. And so here's what I perceive. My purpose in imposing a sentence in this case is to incapacitate Matthew Pahl, to prevent him from taking advantage of somebody like Stephanie Pavlons in the future, of hurting her mentally, emotionally, physically, of punching her, kicking her. I mean, her life, she spent her life being berated, bullied, belittled, and beaten by you. And I'm not going to allow that to happen again. It's not going to happen. So what I have to do is incapacitate you and incarcerate you for the maximum amount of time appropriate. And what I also have to do is send a message to the community, the Pavlons family, and the community as a whole, as it pertains to domestic abusers who kill their partners, that we have to incapacitate those people. And in light of that, as to count number one, I'll impose a sentence of life imprisonment without any eligibility for release to extended supervision. As to count two, I'm going to impose a term of imprisonment of 12 and a half years with 7.5 years initial confinement and 5 years of extended supervision consecutive to the term of life. I'll require that as a condition of your sentence and prison term that you pay restitution in the amount of $8,309 to the Pavlons family for funeral expenses. And although this is a hollow requirement, as a condition of extended supervision, you're not to have any contact with the Pavlons family. I've already indicated the amount of credit that is due and owing. Is there anything you think I've overlooked or omitted from the state's perspective, Ms. Gordon?
No, Judge.
Mr. Galaviz, anything?
you're agreeing to this?
All right, you have 20 days to appeal this decision. If you wish to do so, consult with your attorney. He'll assist you in that regard. Mr. Galaviz, anything?
I'm not sure. I don't think Mr. Paul is agreeing to the restitution for what it's worth. And other than that, I have nothing further.
I agree that he indicates that he is, because he believes that he's innocent, that he believes that he shouldn't pay that. But in terms of setting a restitution hearing, I'll need you to advise the court and the state in writing as to whether he believes that amount is inappropriate. I understand he doesn't want to take responsibility for that. I guess that would be the case. So let's set a restitution hearing, all right, in 60 days. And
Judge,
you'll-
I don't think he's disagreeing on the amount. He's stating what you first indicated, that he's innocent, so he shouldn't pay it.
Okay, so that he's not asking for a restitution hearing.
Correct.
All right, then I'll set restitution at that amount, $8,309.
Thank you.
And I've given him his appeal rights. I believe that's it.
Correct.
Thank you very much, everybody. Good luck.
I don't know if y'all recall when he was getting sentenced last week when we were watching that sentencing. The judge was like, because they wanted to kind of do sentencing that same day, and the judge was like, he needed some time, for the family and different things like that. And he wanted to get a defense time, but after hearing the judge speak, it sounded like the judge wanted some time so he can make sure that he got everything that he wanted to say off, right? Hey, Franklin. So, yeah, I think the judge has some things that he wanted to write down and he wanted to say to make sure that, I tell you exactly, I see you for who you are. Like, no, everybody, remember, this is the same guy that got in the cop car and was like, y'all got the wrong guy. I don't know what y'all doing. Like, they tried this before with this and that. And I was innocent in all them charges. It will be the same thing here. His smart self, right? But he a goofy anyways, because I don't know why he thought he was going to come in that house and bring her purse and keep the purse in the house. He's a goofy. Such a goofy. Yeah, Northwest. And even with him getting away with it before, like, no. That's even worse. Like, if you done did it one time and you got away with it for whatever reasons there were, why can't you just take that as, hey, I got away. Let me be easy. But no. He couldn't do it. You said an hour with lunch. Thank you. Now I don't know what it's going to be tomorrow, right? We got an early day tomorrow. Do y'all want to go into the prep for our other trial that we're going to be starting tomorrow? I didn't know how long this was going to take. You say it sound sorry, it does sound like a narc. Well, thank you, Marilda. Y'all want to go into prep? Okay. I am going to drop our link I'm gonna keep it separate from here. You know, yeah, I'm gonna keep it separate from here. That way I don't have to do a whole bunch of editing. Y'all know I'm trying to learn how to edit. look, I'm trying to learn how to edit. So I am going to let me open up the room and then we'll go over there and we'll discuss what we need to discuss to get us ready for tomorrow, which should be very interesting. Thank you, Jason. Thank you. I'll be trying. I was like, ooh, that gave me some time today. I'm gonna pin my hair up. I'm gonna pin my hair up. Let me see. Enter. I don't know. For some reason, sometimes this studio be ready, and then sometimes I gotta get it ready. This is crazy. Okay, so let me get this and drop this link over here to y'all. View. Did y'all see my thumbnail that I made with me on there? I'm so funny. Okay, here's the link for the new room. All you got to do is click on the link and it will transport you over there. You will just buckle up your seatbelt, click the link, and it will put you over there into our new room where we will discuss the drama and get ready for our case tomorrow. All right, guys, I will see you over there.